Good morning, everybody. My name is Gary Kajalski. I'm with the Division of Real Estate, and today we want to welcome you this afternoon from the Colorado Division of Real Estate in the Department of Regulatory Agencies, which is DORA. And we have the pleasure today of hearing from Marcia Waters, our director of the division, in her Directly from the Director series that touches on important issues for consumers and the real estate industry. Today's installment will cover what the Division of Real Estate does and does not do. We have surveyed questions in advance from the attendees to respond to, and if we have additional time after the presentation, we can address more questions that you can ask in the chat box after the presentation. So there is a chat feature that you can ask questions which we can either answer during or after the presentation for you. Also, just so you know, we're going to be recording today's presentation so that you can also have the opportunity to review it later. So at this time, I'm going to turn the presentation over to Director Waters. Director Waters?
So today I'm going to go through the different regulatory programs that are housed within the Division of Real Estate. And as Gary mentioned, we're located in the Department of Regulatory Agencies. We're one of 10 divisions in that department, and we're really tasked with regulating the real estate professionals. So we're not the division that does land acquisitions for the state of Colorado. That's somebody else. We regulate the real estate professionals that help consumers with their transactions. But before I go into our different regulatory programs, I thought I'd give you a quick overview of the types of regulation that you typically see in Colorado. There's licensure. That's the most restrictive form of regulation, and it's also the most consumer protective. Below licensure is certification, and it's usually equivalent in how it protects consumers, although the barriers to entry are less than a licensure program. Then you have a registration program, which also has reduced barriers to entry, and those programs may or may not protect consumers. Then you've got title protection, and basically with title protection, that's one of the lowest levels of regulation. And basically, if you just satisfy a certain criteria, then you can use a particular title. The ones that I'm going to be talking about today focus on licensure and also registration. So with our different programs, we regulate and we license real estate brokers, mortgage loan originators, real estate appraisers. They all have prerequisite education requirements in order to come into the industry. They also have examination requirements. Those three programs also have to go through fingerprinting. And with the appraisers, they also have to basically apprentice and acquire some experience before they're able to get one of the appraisal credentials that we have. We also register mortgage companies. We license appraisal management companies. And then we have subdivisions that are registered with us and also HOAs. So those are the programs that I'm going to touch on today. I'll talk about common issues that we see, what we don't deal with each of the professionals, and then I'll also go into the complaint process because that's really how a lot of consumers interact with this division. So our oldest and largest program are the real estate brokers. The oversight board for them is the Real Estate Commission. It's a 5-member board. It's made up of industry participants and also members of the public. We've regulated real estate brokers in Colorado since 1925. And as of the beginning of this month, June of 2021, we have 50,091 licensed real estate brokers in the state of Colorado. Basically, when you deal with a real estate broker, they're responsible for bringing two parties together and negotiating the terms of a transaction, whether it be a sales transaction, a lease transaction, or an exchange of real estate. That's kind of the basic definition of what a real estate broker does. And in Colorado, unlike some states that are located in the eastern part of the United States, real estate brokers here have a limited license to practice law. And what that means is with their Practice Act, they are allowed to complete contract documents. And those contract documents either have to be promulgated by the Real Estate Commission or they have to be drafted by a licensed Colorado real estate attorney or licensed attorney here. They can't give you legal advice. That's not something within that scope of limited practice. They can just complete the contract documents. So when you start going onto our licensing database, and if you're querying our licensees, you'll notice with their license numbers, they've got alphabetical prefixes, and that means something to us, and it can mean something to you as well. So if you query a licensee and they have a license prefix that starts off with an FA, an IA, or an EA, that means that that real estate broker is supervised by another real estate broker. And the reason that I tell you this is if you're encountering issues with somebody with one of those license prefixes, one of the places that you might want to go first is to the broker responsible for supervising them. And that is also something that you can find through our licensing database, who that supervising broker is. We call it an employing broker. If you query one of our licensees and their license prefix is II or EI, that typically means that they are out on their own. They're just an independent. And then if you query them and the license prefix is IR or ER, they are the responsible broker. So if you're having issues with somebody in that company, that's who you go to. And then we've also got a license prefix for the actual license brokerages, and that's EC. We have about 1,250 licensed real estate brokerages in Colorado. So for each of those, you're going to have an employing broker that's responsible for them as well. So when you deal with a real estate broker in Colorado, the important thing for you to know is a real estate broker can represent you in one of two capacities. They can be your advocate and act as your single agent. And in that capacity, they're a fiduciary for you, and they need to promote your interests with the utmost good faith, loyalty, and fidelity. In order for a real estate broker to be your advocate or your single agent, you're going to have to sign a contract with them, and that's required by law. The other way that they can represent you is as a transaction broker, and basically they function as a facilitator. They will help you through the process, but they're not advocating for you. And depending on what the real estate broker will request, you may or may not sign a contract in order for them to represent you in that capacity. And unlike a single agent, you don't have to, under the license law, sign a contract in order for them to be your transaction broker. But regardless of what capacity they're representing you in, they do have uniform duties that they have to perform. So they have to exercise reasonable skill and care when they're representing you in a transaction. They have to present all offers and counter offers in a timely manner. They have to advise you to obtain expert advice in those matters that they don't have the expertise in. So this kind of speaks to the legal advice as well. If you're encountering a transaction where you really should be consulting with an attorney, the real estate broker should be telling you you need to consult an attorney about that. Real estate brokers are required to disclose all known adverse material facts that are known by the broker. And one of the main complaint types that we get from consumers has to deal, it deals with the non-disclosure of material facts, but what we have to decipher is what was known by the broker versus what was known by the seller. They've got to provide you with a timely accounting of any funds that they receive from a third party. They have to provide you with copies of any signed contracts, including disclosure documents. And then they have to comply with any local, state, and federal laws and regulations. So if there is a law that you don't want them to comply with, their license law still says that they have to comply with that. So those are the basic duties of a real estate broker. Another thing that you need to keep in mind is before you start disclosing any confidential information to a real estate broker, they should be advising you about the different types of brokerage relationships. So before you start telling them your motivation for wanting to buy a house or wanting to sell a house or wanting to rent an apartment or what your finances are, they need to be making that disclosure to you so that you can make a decision on whether you want to work with them and in what capacity they're going to represent you if you do want to work with them. So now on to what we do regulate and what we don't regulate when it comes to real estate brokers. What we don't regulate is ethics. Ethics is something that falls under kind of the purview of the the National Association of Realtors, and that's a trade association that brokers can choose to be a member of. So they deal with ethics. We deal with the license law, which doesn't necessarily incorporate ethics into it. We don't regulate the property databases that real estate brokers input your properties into. So oversight of the multiple listing services, that doesn't typically fall within our jurisdiction. Now, if there's an error made in an entry by a real estate broker into one of those databases, that may fall into the Real Estate Commission's jurisdiction, but regulation of the database itself, that's not us. We don't regulate the realtor boards. And we also don't regulate the behavior of unlicensed sellers. So if you have a seller that knows that their property has an issue, they don't disclose it, and the broker is not aware of it, that's not something that would fall into our jurisdiction, but that may be something that you'd have to pursue civilly against the seller. And then there's customer service related issues that we see come up from time to time with real estate brokers that really speaks to kind of how they manage their business. Being tardy for appointments, being rude, unprofessionalism in conduct. And we've seen quite a bit of that over the past year where it's, people disagreeing with political views. We don't have any jurisdiction over that. And we also don't regulate their attire. We had one broker whose business model was to show up for showings wearing a bikini. That doesn't fall within the license law, so that's not something the commission can do anything about. What we do regulate with the real estate brokers is how they manage funds of others. So they've got specific accounting requirements. If they abuse other people's funds, that falls into the commission's jurisdiction. If they make false promises to consumers, that's also something that falls within our purview. Failing to perform their brokerage duties, and that speaks to whether they're the single agent or a transaction broker for you. Failing to disclose known material facts. Unlicensed practice, one of the big issues that we deal with as far as unlicensed practice is concerned is a lot of people are unaware that if you're going to manage the property for another and it's going to be a rental, that in most instances is going to require a real estate broker's license. So if you're out there renting your neighbor's property out on their behalf, chances are you have to be licensed with us. And if you're not licensed, the Real Estate Commission can issue an injunction against you to make you stop practicing. And then there's predatory behaviors that will fall within our jurisdiction if there's a real estate broker involved. And those are mortgage fraud, equity skimming, and in some cases we see investor equity theft. So that's the real estate broker program. Our second oldest regulatory program is the Board of Real Estate Appraisers, and they have been around since 1991. Appraiser regulations came about as a result of the savings and loan crisis back in the 80s. There was a federal law passed in 1989. It was the Financial Institutions Reform, Recovery, and Enforcement Act, and that created appraiser regulation. So this is a program that not only at the state level do we enforce, but we also have federal oversight as well. As the beginning of this month, June of 2021, we have 2,936 credentialed real estate appraisers in the state of Colorado. So they're a much smaller population than the real estate brokers. And really the purpose of an appraiser is they will render a value opinion on real property. It may be oral or written, and it's based on an analysis of the market, the property characteristics. And one of the big things that I don't think a lot of people understand about appraisers compared to like our real estate brokers is they don't advocate for a transaction. They are an unbiased party that is engaged to render the value opinion. And in most transactions, that value opinion is used by a lending institution to decide whether they want to take on the risk of lending on that property. Although there's appraisals done for more reasons than just mortgage transactions, that's kind of the high volume that we deal with. So with the appraisers, we have 4 different levels of licensure. So if you look up an appraiser in our system and their prefix is an AV, that means that they're an ad valorem appraiser. They only work for an assessor's office, and they should not be out there doing fee appraisal work because they don't have the level of licensure necessary to do that. So an ad valorem appraiser is not going to be doing an appraisal for a mortgage transaction. Then the next level of licensure is a licensed appraiser, and they can do non-complex 1 to 4 residential unit transactions with a transaction value of less than $1 million, or they can do complex 1 to 4 residential unit transactions with a transaction value of less than $400,000. And the way that they define the transaction value is based on one of 2 things. If there is a loan involved, it's going to be the amount of the loan. If there is no loan involved, it's going to be basically the transaction value of that interest in real property. Then next, what we have are the certified residential appraisers, and they can basically do an appraisal of any residential property except for subdivisions in which there's a development analysis or an appraisal required. And then you've got the certified general appraisers, and basically they're qualified to value any type of property as long as they have the competency to do so. So when we deal with the appraisers, a lot of the consumer complaints that we get in about appraisers has to do with their value opinions. A lot of people, particularly in refinance transactions, and specifically refinance transactions that involve reverse mortgage loans, a lot of the complaints has to do with the value. The consumer doesn't like the value. The Board of Real Estate Appraisers does not regulate value opinions. So that is something that if you file a complaint saying, I hate the value opinion, we're going to close it at intake because we don't have jurisdiction. Another issue that we see with the consumers about the appraisers is the timeliness of the completion of an appraisal. You know, they didn't meet their deadline. They were 2 days beyond the deadline. Timeliness of completion is another thing that the Board of Real Estate Appraisers does not have jurisdiction over. And then lastly, the common complaint that we get from consumers has to do with an appraiser that accepts an assignment, but then doesn't actually follow through with an appraisal report. The only time that the board is going to have jurisdiction over that scenario is if there has been payment rendered to the appraiser and they've accepted it, then we'll have jurisdiction. But if they've accepted an assignment and never followed through with it and they were never paid for it, that's not within the board's jurisdiction. Now, what we do regulate with the real estate appraisers is we do regulate ethics with them. That's part of their professional appraisal standards. We also regulate the methodology and the standards that they use to develop an appraisal. So if they're not analyzing the market, they're not analyzing the property characteristics, they're not familiar with the geographic market that they're appraising in, those are all things that will fall into the board's jurisdiction. And we also deal with competency. So I brought up before, a certified general appraiser can appraise anything, but if they have no experience appraising a particular type of property, they either have to gain that experience or they need to turn down the assignment. And if they don't gain the experience, but they do the appraisal assignment, that's something that the board can say that they did not have the competency to do. And with the Board of Real Estate Appraisers program, we also license appraisal management companies. These are companies that typically act as a firewall between the appraiser and the lending institution. And really their requirements, their job is to hire an appraiser. And then once the appraiser is hired and the appraisal report is completed, they should be doing some sort of quality control as far as reviewing that appraisal to make sure that there aren't any obvious flaws involved with it. And if there are issues with the appraisal, they have a duty to report that to the Board of Real Estate Appraisers. One of the things that you will see with an appraisal report when there is an appraisal management company involved is in that appraisal report, the appraiser will put in the cost of the appraisal report. And the reason that that's a requirement is when you look at your settlement statements, when you go to close on that transaction, if you just see just kind of a vague cost for the appraisal, you can then subtract out that appraisal report from that appraisal cost, and that difference is the amount that the appraisal management company was paid. That was a disclosure issue that came up when we first looked at regulating appraisal management companies. So that's why you'll always see the cost of the appraisal report in the report itself when there's an appraisal management company involved. Okay, so our last licensure program is the mortgage loan originators. This started out as a director model program back in 2007. It transitioned to a board model program in 2010. They're a 5-member board, and like our other boards, they're made up of industry participants and also members of the public. and interesting, back in 2007, when we started regulating mortgage loan originators, we were one of the last 2 states in the country to actually regulate them. And this came out of kind of the mortgage crisis that happened in 05, 06, and 07. So as of earlier this month, we have 22,394 people licensed with the state of Colorado to originate mortgage loans. The other interesting part about this program is about 82% of our licensees are not located within the state's boundaries. Most of our mortgage loan originators are outside of Colorado, and most of them hold licenses in multiple jurisdictions. And I actually think our current license population is probably the highest it's been since we started regulating the mortgage loan originators. So by definition, in Colorado, a mortgage loan originator is an individual who takes a residential mortgage loan application or offers or negotiates the terms of a residential mortgage loan. Mortgage loan originators in this state have a duty of good faith and fair dealing in all communications and transactions with a borrower. And what that includes is that they cannot recommend or induce a borrower to enter into a transaction that doesn't have any reasonable net tangible benefit to you. So in looking at all of the different terms of a mortgage loan, for example, if there was only one difference, you've got 2 identical mortgage products. One has a 6% interest rate, one has a 12% interest rate. Our licensed mortgage loan originator here should not be inducing you to go with that 12% percentage rate loan, because that's not what you're going to have a reasonable net tangible benefit with. It's going to be the lower cost option. They're also required to make a reasonable inquiry about the borrower's current and prospective income, any existing debts or obligations, and any other relevant information that's going to come into whether you qualify for a loan or not. But the important thing to recall with a mortgage loan originator is that if you give them bad information, that doesn't rest on them. That's something that we would look back at the borrower, and that may absolve them in a complaint. Is if you gave them bad information and they move forward with that, that may not fall back on the mortgage loan originator. A lot of the complaints that we get with consumers about mortgage loan originators has to do with fees. So a mortgage loan originator cannot charge you an upfront fee for their services. They can charge you for third-party services, but they can't overcharge you. They can only charge you for the specific amount. So if you have an appraisal done, they can charge you upfront for that appraisal fee. If they're collecting upfront third-party fees and then those services are never rendered, they have to refund those fees. Now, if there's a loan commitment issued in a mortgage transaction and you don't follow through with the loan, the mortgage loan originator can charge you a fee of up to $300 for the services that they have rendered. But their full fees that they may collect, those cannot be charged until the buyer actually obtains a mortgage loan from a lender with the terms and conditions agreed upon. So you should not be getting charged any upfront fees from a mortgage lender for their services in a mortgage transaction. Now, with the mortgage loan originators, what we don't regulate are the loan originators that work for state or federally chartered banks. They are regulated by somebody else. We also don't regulate mortgage servicers. Chances are they would probably fall under the jurisdiction of the Attorney General's office. And then loan processors and underwriters don't fall within the jurisdiction of a mortgage loan originator. So we don't regulate those either. What we do regulate is deceptive advertising. So if somebody is advertising kind of bait and switch terms that don't exist, that is something that the Board of Mortgage Loan Originators would have jurisdiction over. Placing borrowers into loans with terms or conditions that are of no benefit to the borrower, weren't agreed upon, or that the loan originator themselves don't fully understand, that's something that would fall within the board's jurisdiction. We don't see it very often, but occasionally you may see a loan originator that falsifies documents. They may sign documents on somebody else's behalf without their authorization. They may make up income or asset information to make the borrower look like they actually qualify for a loan. That is also a behavior that falls under the board's jurisdiction. And then also, they're not allowed to originate loans where they know that the borrower is going to default. So in those instances, the board would have jurisdiction over the licensee's practices as well. Now, I brought up earlier that we've got registration programs. We register mortgage companies, so we have very limited oversight over them. And basically, the only oversight that we have with a mortgage company has to do with them allowing somebody to practice without a license, advertising violations, and then they have records keeping requirements. So if they don't keep their records for the amount of time that they're supposed to under the license law, that's something that the board could take action against. So the other registration program that we have is the subdivision developers, and they fall under the jurisdiction of the Real Estate Commission. That's the board that also regulates the real estate brokers. These are very limited subdivisions, though, that the Real Estate Commission has jurisdiction over. They are raw ground subdivisions of 20 lots or more, with the lots being 35 acres or more. They're condo conversions of 20 units or more. They're timeshares of 20 units or more. And then there's 20 or more proprietary leases in a cooperative housing corporation. And we don't see those very often in Colorado. So one of the interesting things about the subdivision program, which we don't have with the other programs, if you're engaged in unlicensed practice, we could refer you over to criminal law enforcement, and it's a misdemeanor offense, or at least it used to be. With the subdivision developers, the failure to register as a subdivision developer under the Real Estate Commission is actually a Class 6 felony, and it can carry treble damages. So it's really important that the few subdivisions that have to register with the Real Estate Commission do. And I believe we have about 272 registered subdivisions with us. We do not regulate kind of the standard lot and block subdivisions that most of us live in. So like the Pulte homes, that's not something that's going to fall into the Real Estate Commission's jurisdiction. And a lot of what we see, really the subdivision program is pretty quiet. Most of what we do is registration. We get a lot of consumer complaints about timeshare scams, and those are typically something that fall outside of the Real Estate Commission's jurisdiction. And the typical scenario that we hear about is you may have a consumer that lives in New Jersey, they have a timeshare interest in Belize, and they've had somebody reach out to them offering to take that timeshare interest off of their hands. But they give an address in Denver, and it's usually a vacant parking lot in Denver where the address goes to. And the entity offering to take the timeshare off of the consumer's hands doesn't. They usually end up in a worse financial situation. While that's not something that falls within the Real Estate Commission's jurisdiction, we do try to get a lot of consumer information out about those scams. And we also try to put consumers in contact with the appropriate criminal law enforcement agency that is able to address those types of timeshare scams. So the last registration program that we have is the HOA Information and Resource Office. And all of our registration programs are very unique, this one in particular, because HOAs are required to register with us, but if they don't register with us, what it amounts to is they can't enforce any liens that they have placed on properties until they activate their registration. With this program, they can file complaints with us, but we don't have the authority to investigate those complaints. What we do with that data is once a year, we will release an annual report. And we have been posting that on our website when it's released, that basically just gives kind of an overview of registration data, the common complaints that we get, who are the complaints against, because they can be against the HOAs, they can be against the community association managers that help manage those HOAs. And I know that that annual report is used regularly with the legislature when they start contemplating running legislation to deal with the different issues that they hear about with HOAs. This program also acts as a clearinghouse of information for both unit owners and HOA board members. And we do hold monthly forums for the HOA office to address different consumer issues. And there are a ton of resources about HOAs on our website. So if you have questions about HOAs, I would definitely encourage you to kind of peruse our division website, because chances are your questions are addressed in that information. So those are our regulatory programs. One of the leading ways that we interact with consumers is through our complaint process. And that goes for any of our licensure programs and also the registration programs to some extent. So typically the complaints that we see have to do with real estate brokers, appraisers, and mortgage loan originators, just because they are the licensure programs and the standards are higher as far as how they have to practice. So when we're looking at complaints, those need to be received in writing. You can either go on our website and file a complaint through our electronic database. If that is not something that you're able to do, you can submit a written complaint, and we have a lot of those that are mailed in at this point. If you wanted to drop one off, you could do that as well, although our kind of in-person hours are limited these days. And if for some reason you are not able to file a written complaint, please reach out to us and we can make some accommodations so that we can address your complaint and hopefully it falls within our jurisdiction. But once we receive a written complaint, what we'll do is we will review the complaint to determine whether if any of our boards have any jurisdiction over the essence of the complaint. If the subject is something that falls outside of one of our board's jurisdictions, the complaint will get dismissed at intake and no further action will be taken, and you'll be notified that we've dismissed your complaint. A lot of the time what we'll get are incomplete complaints where there's just not enough information for us to determine whether something falls within the board's jurisdiction. And in those cases, we'll reach out to the complainant to try to get some more information so that we can actually make a decision on whether it's going to be assigned for an investigation or if it needs to be dismissed at intake. And we give you a 30-day window to respond with that additional information. If we review it and right away we can identify, no, this looks like something that's within our jurisdiction, it gets assigned to an investigator. The investigator will notify the complainant that it's been assigned. And then we'll also send out a notification letter to the licensee, because each of our programs have requirements for licensees to respond to the board when there's been a complaint filed. So they'll get a copy of the complaint. Sometimes there's supporting documentation that's submitted with a complaint. If it contains confidential information, we may withhold that from the licensee or it may be redacted, but they do get a copy of the complaint because they have to respond to the board with a written response, and also they have to give us a copy of their transaction file or a work file in the case of an appraiser. Once we get their response, the investigator is going to start conducting interviews, and they'll interview the respondent and the complainant and any witnesses. They're going to gather data, whatever evidence may be available, and they'll go through this whole evidence collection process. And once they've completed that, in most cases, they'll draft a report, but if it's pretty obvious after their investigation that we don't have any jurisdiction, it may be something as simple as a dismissal letter indicating, listen, this is a summary of the investigation that we performed. We did not see any violation of the license law, or the behavior that the licensee engaged in doesn't fall within the jurisdiction of the commission. And in the dismissal cases, those are closed and there's no further action taken. Now, in the case where we do identify wrongdoing on the part of the licensee, the investigator is going to draft a report, and the report will be basically viewed by whatever board has jurisdiction over that program. So, and a lot of our cases will go to the actual public meetings. There's a few things that we will handle at the staff level, like if they didn't have their continuing education requirements or they didn't have the requisite insurance requirements. Those are something that we can handle on behalf of our boards. But usually the practice standards are such that they will go in front of the board at their public meeting. The board will engage in a discussion, and ultimately it's the board that will decide what type of violation of the license law has occurred and also what type of discipline they're going to seek. And for most of our programs, that's going to range from anywhere to from a letter of admonition, which is like a warning letter, all the way up to the maximum that they can impose is revocation of the license and maximum fines. And maximum fines depends on which program, because there's variation amongst the different programs. We only have one program that is able to impose restitution, and that is the Board of Mortgage Loan Originators. And it doesn't get imposed very often because it's it can be very difficult for the board to distinguish, okay, so what is actual restitution versus other types of damages. So with the Real Estate Commission and the Board of Real Estate Appraisers, we have a lot of consumers that want to have restitution imposed because, like with a real estate broker, maybe they've lost their earnest money deposit. The same thing may happen with a real estate appraiser. We do not have the authority to order restitution under those two programs. It's only the Board of Mortgage Loan Originators. Once one of our boards has made a disciplinary decision, we have a unit within the division that works on trying to negotiate settlements of those disciplinary cases. If we're able to negotiate a settlement of those cases, that same unit also tracks compliance with the different disciplinary terms. So if the licensee was told to take remedial education or pay a fine, that unit will make sure that those terms are met. And if they're not met, it will go back to the board as a stipulation violation. And with a lot of our cases, the language in those stipulated agreements indicates failure to comply with the terms of a stipulation results in revocation of the license. So it's really in the licensee's best interest to comply with those terms. If the unit within the division cannot negotiate the settlement of a disciplinary case, then what will happen is we will refer it over to the Office of the Attorney General, and they are the legal counsel for our different boards and commissions. So they'll try to resolve it, but ultimately, if they can't get a resolution through mediation or a pre-hearing settlement conference, what they're going to do is they're going to start litigating that case through the Office of the Administrative Courts. If it goes through that hearing process, an administrative law judge is going to hear the case, and then they are going to issue an initial decision with their finding of fact and conclusion of law, and then they will give their own kind of disciplinary decision. Administrative law functions a little differently than how we all get to see kind of criminal law play out, either on TV or, you know, in real life. When an administrative law judge renders an initial decision, that decision actually goes back to the affected board, and the board could say, no, judge, you got it wrong, or no, this is the appropriate level of discipline. So they can actually alter the administrative law judge's initial decision and issue a final agency order with something different from what the judge had recommended. And then if we go through that entire hearing process and, you know, the commission is unhappy with the decision or the licensee is unhappy with the decision, we go through an exceptions process, which is it goes back in front of our boards and they can alter the decision. Once the final agency order is issued, if the licensee is still dissatisfied with the outcome of that case, really at that point, they're looking at going to the Court of Appeals to appeal that decision. So kind of the moral of the story is when we have something that goes through the administrative hearing process and then is going to go through appeals, the administrative hearing process can take about 2 years. And if one of our boards has voted to revoke a license, that revocation is not immediate when they make that initial ruling. That licensee still gets to practice all through the hearing process because the revocation hasn't been finalized until the board issues a final agency order. So if you file a complaint with us and it's going through the administrative hearing process, just know it's probably going to be a long haul before the actual disciplinary decision becomes final. Now, typically, after the final agency order has been issued, if there's going to be appeal to the Court of Appeals following that, usually that disciplinary decision is still in effect. They'll go through the appeals process, and if they reverse it, then you'll see the license action change, but that doesn't happen very often. We don't have too many people that take it through the actual appeals process. So one of the questions that comes up quite a bit with our complainants is what happens if I file a complaint with one of your boards and I'm dissatisfied with their disciplinary decision? So really, there's nothing that the complainant can do. There are times where the complainant may raise, hey, I think you missed something. And what we'll do is we'll go back and we'll have a couple different people within the division review that to see, did we miss anything? Did the board miss anything? Do they need to reconsider something? That doesn't happen too often. If you're just unhappy that, I really wanted him to have his license revoked and you only gave him remedial education, as a complainant, there's really not much that you can do. I mean, that's the board's decision, and they have been entrusted with that authority. And then one of the other questions that comes up as far as filing complaints is, how can I best file a complaint? And so bear in mind, we also take complaints that are filed anonymously. Whether you're going to file it under your own name or do it anonymously, please make sure your complaint is very thorough and as well documented as you can. And also, if you've got copies of the transaction documents, that's going to be really helpful for us. Please send us the copies, retain the originals, because in very, very rare instances are we going to ask for actual original documents from you, and those are usually going to be cases where the allegations are that one of our licensees forged signatures. That doesn't come up very often, but we do request that you provide us with copies of those documents. And if you file a complaint against an appraiser, we're going to need a copy of that appraisal report, because without the appraisal report, we can't proceed with an investigation. That is critical as far as those complaints are concerned. Another question that comes up with our regulatory programs is there a statute of limitations for filing complaints? And really, the statute of limitations goes back to when those individual regulatory programs were created. So like with the Real Estate Commission, technically, you could file a complaint dating back to 1925. I don't know how successful we would be at investigating a complaint that old, and I would guess that licensee is not around anymore. But it's 1925 for the Real Estate Commission, it's 1991 for the Real Estate Appraisers, and it's 2007 for the Board of Mortgage Loan Originators. So we can go back quite a ways. So another question that comes up as far as our licensees are concerned is, what type of professional education are they required to have? And each of the three licensure programs, the real estate brokers, the appraisers, and the mortgage loan originators, they all have post-licensure education that they have to complete as well. So not only do they have to have license education before they become licensed, they also have to do continuing education afterwards. And we will regularly audit our licensees to make sure that they are complying with those license law requirements regarding their education. So at this point, Gary and Jeff, do you want to launch into the Q&A? And just as a reminder, on our website, we do have a lot of consumer information, not just about HOAs, but also about the real estate transaction process and what our different license types do.
Sounds good. Well, thank you so much, Marcia. A lot of great information there. I have a lot of questions that came in before and during, so I'll hop right into it. You mentioned the license law. Can you tell us a little bit about what that is and how somebody might learn more about the license law?
So to kind of give you some background, in Colorado, we go through a sunrise and sunset process. And any time that the legislature is going to consider regulating an individual profession, you're required to go through a sunrise process. That is managed by DORA's Office of Policy Research and Regulatory Reform. The acronym is COPPER. They are separate from the divisions within DORA. And COPPER is going to evaluate different criteria. And after they do this analysis, they will issue a report which will either recommend regulating a profession or not. And typically, when there has been a recommendation to regulate a profession, you may see legislation go through the legislature to regulate that profession. And that is, if you've got a bill that goes through the legislature to regulate that profession, that becomes the Individual Practice Act for that profession. And then periodically, they will do a sunset review to see if regulation of the profession is still necessary. We are currently undergoing one of those for the Board of Real Estate Appraisers. And again, Copper does the analysis. They've got different criteria that they evaluate the program on. Colorado is a regulation light state, so their goal is to regulate professions at the lowest threshold necessary to ensure that consumers are protected, because they don't want to create this overly burdensome barrier to entry. So that's how the license law comes up. So each one of our licensing programs went through a sunrise process, and that's how you came up with the Real Estate Broker Practice Act, the Appraiser Practice Act, and the Mortgage Loan Originator Practice Act.
And if somebody wants to learn more about it, they can visit our website. I'm fairly certain each of our programs has the requisite information there.
So on our website, you can go on and view the license law. We issue a real estate manual on an annual basis, and the license law is actually contained in various different chapters of that real estate manual, and those chapters can be found on our website.
Great, thank you. I think you talked about this. So does the division maintain an open database of licensees and disciplinary actions across the board?
So you can definitely go on and search for anybody that's licensed with us. Certain disciplinary actions will not show up on the licensing database. Each board has an array of tools to deal with different practice deficiencies. So if it's a final agency order, those are something that you're going to see on our database. If it's a stipulation for diversion, that's not something that's going to show up as discipline on our database, because stipulations for diversion contain language that, if the licensee completes the various different terms, it will be treated as a dismissal. But it's still a stipulated agreement, and if you requested it through the Colorado Open Records Act, we would provide you with a copy of the stipulation for diversion. So some things are viewable on the website, some things are not.
Okay, thank you. How does the division proactively identify bad actors and hold them accountable?
So one of our most proactive ways of dealing with the industries is we have audit authority under the Real Estate Commission, and it's mainly to look at financial accounts. And that is one of our largest areas of consumer harm. Is not all of our real estate brokers hold trust accounts, but typically when they're doing property management, that is something that they are holding, because they're holding security deposits for people, and they're also accepting rent monies. And so we will go in and we will audit those accounts just to make sure that, number one, they're being held in trust accounts, which that's protecting the consumers, that they're not being commingled with broker funds, and also to make sure that they're not being used for any other purposes than they should be.
Great. And you mentioned rental funds. Is a license required to perform property management of short-term rentals and vacation rentals?
So short-term rentals and vacation rentals typically are not going to fall within the Real Estate Commission's jurisdiction, because those operate very similarly to a hotel or a motel. It's a license to use agreement versus a lease agreement. So typically a short-term rental is not going to fall within the Real Estate Commission's jurisdiction. But if it's short-term rentals being performed by a licensed real estate broker, there are accounting standards that pull them into the commission's jurisdiction. So if they're mismanaging those short-term rental funds, the Real Estate Commission can take action against the real estate broker.
Thank you. You talked a little bit about education. What does the commission do in terms of providing exam prep materials for those who are looking to get a license?
So we don't actually provide the exam prep materials. Those are typically something that you can get from the education providers.
Good to know. With regard to investigations, how long does a typical investigation take from start to finish?
So it's going to depend on the complexity of the issue that we're investigating. We definitely try to get all of our investigations done within 8 months. That's the goal. But like I said, some take a lot longer to do than others. Some are, you can manage them in the time of an afternoon and get them closed out. It just depends on how complex they are.
Gotcha. How does the division fund itself?
So we are a cash funded agency, which means that we are funded by license fees. So the general Colorado taxpayer is not paying for our operations. We're not getting any money from them. The Real Estate Commission's program is funded by real estate broker license fees and also subdivision registration fees. The mortgage program is funded largely by the mortgage loan originator fees and the mortgage company fees. The appraiser program is funded by the appraiser license fees and also the appraisal management company fees. And then the HOA program is funded by the HOA registration fees.
Okay. You very distinctly talked about the different types of brokers and the different license types. Can you talk a little bit about the roles and duties of an employing broker?
So an employing broker is responsible for overseeing the actions of all the brokers that they basically employ or report to them. So their primary job is to make sure that they are complying with the license law and that violations of the license law don't occur or reoccur. So they kind of serve as our kind of primary line of defense. We would hope that issues with an individual broker's practice would be addressed first by the employing broker kind of before coming to us, but that doesn't always happen. And if we get a complaint, we're still going to investigate it. What we will look at, though, when we start getting complaints about individual broker practices and those brokers are supervised by an employing broker, is we'll evaluate whether there appears to be a lack of supervision. And if there does appear to be a lack of supervision on the part of the employing broker, we will open up a complaint and start an investigation into the employing broker as well.
Okay, great. With regard to what licensees should be doing and not doing, does the division give advisory opinions to real estate brokers on whether or not an action taken or is going to be taken, whether or not that would be in compliance?
Not on individual actions. So the Real Estate Commission has a series of commission position statements. And I usually kind of describe those for the most part as kind of like being the roadmap to the regulator's mindset. It will usually they will lay out different expectations about the different regulations. The position statements are strictly guidance. They don't carry the effect of a rule or a regulation, but they do provide the licensees with some guidance about different practices. You can request a declaratory order from our different boards and commissions, and that is when there's a gap in statute that hasn't been also addressed by a regulation. And the whole purpose of a declaratory order is to terminate a controversy. The only thing about requesting a declaratory order is the board may or may not decide to rule on it. So you may ask them for guidance about kind of a widespread, controversy, and they may say, yeah, we're not going to rule on this.
Okay, good to know. With regard to mortgage loan originators, can the same MLO assist with refinancing transactions on the same property more than once?
There's no restrictions at the state level on doing that.
Okay.
And usually when you're looking at the real estate brokers and the mortgage loan originators, those are two different types of professionals that I think really do try to rely on repeat business. So it's not uncommon to see them represent the same people over and over again.
Okay. Can I choose a lender on a builder transaction and retain the incentives?
So typically the builder transactions, the incentives are tied to using the builder's lender. And that has been something that it's kind of at the state level, we've questioned how does that comply with RESPA, the Real Estate Settlement and Procedures Act, because it's kind of one of those required use. To get these incentives, you have to use my lender. And one of the dangers as far as a consumer is concerned about using a builder's lender is when you start discussing your finances, you're losing that kind of veil of confidentiality. So I will tell you, we don't regulate RESPA. That falls under the jurisdiction of the Insurance Commissioner, the Office of the Attorney General, and the Consumer Financial Protection Bureau. And we also don't regulate builders. So those types of issues are probably best addressed by the Consumer Financial Protection Bureau, or the CFPB as they're frequently called.
Okay. Can a seller, if I'm a buyer, can a seller or broker require that I pre-qualify for a loan with their preferred lender?
So they can make that ask, but again, kind of like dealing with the builder and the builder's lender, that is something that I would hope your broker would be cautioning you about, because you are going to be giving up confidential information if you decide to do that. A pre-qual letter typically just says you qualify for X amount, but we have seen some complaints where the seller has gotten into the weeds and really wanted some very specific confidential information, and that is going to harm your bargaining power as a buyer. So I think you need to be very careful and thoughtful about what they're asking of you and what you actually provide.
Okay.
Pre-qual letters are pretty standard that they're going to ask for.
Mm-hmm.
They don't usually kind of give away the farm as far as your confidential information is concerned. But you never know, particularly in the type of competitive market that we're in. When they start asking, I want to know your income, I want to know your assets, that's going to speak to your confidential information and could really impair your ability as far as bargaining power.
Okay. Got just a couple questions regarding appraisers. If I am buying a home, and basically what happens if the home that I want to purchase does not appraise for the contract amount?
Well, typically, and I mean, this is going to depend on what your contract language also includes, because we're starting to see appraisal gap language included in those transactions as well. Typically, if your appraisal comes in below the purchase price, that's when you as a buyer need to make a decision of, okay, so if the seller's not going to come down, am I going to make up that difference, or am I going to terminate the contract because of the appraisal? Now, if you've got the gap clause in there, you've already committed to coming up with a certain amount of money to make up for that gap.
So that's another question we have. Can you talk a little bit about what an appraisal gap is and how it might be used?
So that is basically, that gives, particularly in this competitive market, that gives the seller the assurance that if that appraisal comes in below the contract price, which you have a lot of offers being submitted on one property at a time, and they're typically well above the list price, that appraisal gap is going to give that seller that assurance that if the appraisal comes in below the contract price, which is probably going to happen, that you're still going to follow through with that transaction, because you're going to make up that gap between the appraised value and the contract price.
Gotcha. So if I understand correctly, if I'm buying a home and we offer $100,000 and the appraisal comes back at 80, the loan is only going to cover that 80, and then as the buyer, the promise in that appraisal gap coverage would mean that you have to make up the $20,000 difference out of our own pocket. It doesn't come from the lender.
Well, yeah, if the contract was for $100,000 and you're getting an $80,000 loan, and the appraisal comes in at $80,000, you're going to have to come up with that difference.
Gotcha. Well, Marcia, those are all the questions we received before and during. Thank you very much for all of that information.
Well, thank you.
Yes, Marcia, that was a lot of information in a short period of time. That was fantastic. And folks, those of you in attendance, we want to remind you that this has been recorded, so we will have the link for you. It takes about an hour to upload it, and we'll have it on YouTube, so you can go through and watch again and get this great information. So we want to thank Director Waters very much for doing this preparation. She did a lot of preparation for this, and it was a lot of great information. And we want to thank you all for attending, and have a great rest of your day. Thank you.